Gotta cut it off. We have so much material to cover today. Now, excuse me, that was Eitan Katz, Matovu from his album Unplugged, his first Unplugged album. How's everybody doing? Let's light up the darkness. A good Moed to you. It's Chol HaMoed, the intermediate days. It's like a vacation, but not a vacation. Can we work on the intermediate days of Passover? Only to avoid a significant loss, and as long as it doesn't involve excessive exertion. But of course, we can always be learning Torah together. Who is with us on a Tuesday evening? Yehuda in South Carolina, Melissa in Great Neck, Stephen in New Hampshire, Nancy, North Carolina, Tom, wishing everyone a good evening, Bella in Florida, Rick in Chicagoland, Victoria in New Orleans, Paula in Chicago, Ruth in Kentucky, Lucy in Minnesota, David in Indiana, Heather in Maine, Donna in Ohio, Paul in the Great Northwest, Patrice in Utah, Bill in Mid-Missouri, Susie in California, Sharon in New Jersey, Renee in Indiana, John in Maine, Francisco in California, Guy in Ohio, Zach in Vegas. Welcome, everybody. Okay, so yesterday, and I hope it doesn't happen again. Right now, the camera seems to be working fine, but we got frozen a little bit before we reached the finish line when we were doing the highlights of 4 pages. So I just want to pick that up where we were. We were discussing Mishna number 7. Which is this general requirement that a woman coming out of a marriage, whether it was a betrothal or a full marriage, whether she was widowed or divorced, so the sages said she has to wait 3 months before she gets married again. And the reason is so that we're sure that if she has a child from that previous marriage, it's recognized that that's the father and not the new father, that in her new marriage, that this man would be the father. That's especially important, obviously, in Yibum, because if she was pregnant by the deceased brother who died, and it's a viable child, so then there is no Yibum. So that's just another very important reason to wait. But even generally speaking, even when Yibum is not a factor, the sages said a woman has to wait. And that's even if it's impossible for her to be pregnant. On account of all the cases where the woman might be pregnant, they didn't want to have different rules for different situations, so they just laid down that general rule that a Jewish woman coming out of a marriage that needs to wait 3 months before she gets married again. And even before getting betrothed, right? Again, there would be no issue if all she's doing is getting betrothed and isn't going to have relations with the new husband. So, there's no concern that the pregnancy would be ambiguous, whether from the previous husband or the new husband. Still, they said, wait 3 months to even become betrothed. There were some minority opinions that disagreed with that, but that was the general rule. So we were in the midst of restarting the Gemara on that Mishnah when the screens froze yesterday. So I'll just take that up again. That the Gemara questions the Mishnah's opening clause. Granted, she should not enter into Yibum, as she might already be pregnant, which would still not be noticeable during those first 3 months, and perhaps the baby will be viable, and in that case, Yibum would not apply. And if she then had relations, thinking it was Yibum, with her brother-in-law, right, the brother who's going to step in and perform Yibum with his dead brother's widow, since Yibum wouldn't apply if there was a viable child, in fact, that would be a transgression. He would have slept with his brother's wife, which is never permitted, even after the brother dies. So for sure, we should wait those 3 months. And then the Gemara asks, okay, so that's why you wouldn't perform Yibum, but why not perform Chalitza? Because they're just going to go their separate ways anyway. And if it turns out that Yibum didn't apply and the Chalitza therefore wasn't necessary, okay, so then it would have been a meaningless event. But what's the harm? That was the question that was asked. And so the Gemara asks, well, why would it matter? Why not let her perform chalitza, even though it is possible that she is pregnant? And then, if it becomes necessary, require a public announcement to be made for her so that people would know that this chalitza was unnecessary. Because you might say, well, if it was a meaningless chalitza, what's the impact? Well, the impact would be that if she performs chalitza, which is a public ceremony, then she would be prohibited to ever marry a Kohen, to ever marry a priest who's not permitted to marry a divorced woman. And a chalutza, a woman who has had chalitza performed, is like a divorcee, is considered like a divorcee according to Jewish law, and therefore she's prohibited to marry a priest. So then you could say, okay, well, if it turns out that that chalitza was meaningless, so you make a public announcement. It was a meaningless chalitza, and if she wants to marry a priest, and if a priest wants to marry her, it's permitted. But then the Gemara will say, yeah, well, what if somebody was there at the chalitza ceremony but missed the public announcement, and it could lead to those difficulties? And that's why they say she should wait 3 months when she comes out of any marriage, including in a potential yibum situation, and even to perform chalitza, as well as to have any kind of marital relations or to get married again. Then we skip forward to 42a, right? That was a page from yesterday. We were only doing highlights yesterday because it was a 4-page day. And I'm just going to read the highlight from 42 that I had prepared, and then we'll get into today's daf, which is actually page 43 here in Tractate Yevamos. So that last highlight that I wanted to read yesterday, the Mishna states, and similarly, all other women may not be betrothed or get married until they have waited 3 months. And the Gemara asks, granted, a Yevama has to wait, the widow of a man who died without child, in accordance with the reason that we said that if she is pregnant with viable offspring, consummating the levirate marriage would violate the prohibition against engaging in relations with one's brother's wife. But with regard to all other women, why shouldn't they remarry immediately, even if they are pregnant? And Rav Nachman said that Shmuel said, it is due to the fact that the verse states, with regard to Abraham in Genesis 17:7, who is God going to be to the Jewish people? To be a God to you and your seed after you. Which indicates that the divine presence, the Shekhinah, the presence of God, the manifest presence of God, rests with someone only when his seed can be identified as being descended from him, i.e., there are no uncertainties with regard to their lineage. Therefore, to prevent any uncertainties concerning the lineage of her child, the woman must wait, so that it will be possible to distinguish between the seed of the first husband and the seed of the second husband. After 3 months, if she has conceived from her previous husband, the pregnancy will be noticeable. She could get married, perhaps. There's going to be a problem with that. But if she got married once she's already showing that she's pregnant from the previous husband, okay, so everyone knows that this baby was conceived by the first husband. Now she's marrying this other husband. He might step in and be the stepfather, might even become, the yibum father, as it were. But everyone will know that the baby was conceived by, he won't be the yibum father. Never mind that. That was just silliness. But the point is she could marry another man and he could become the stepfather of that child, but that child was conceived by the previous husband. You need to know that with certainty. So Rava raised an objection from a Baraisa. Therefore, on account of the requirement to wait 3 months, a male convert and a female convert who were originally married to each other and converted need to wait 3 months before they may remarry following their conversion. So Rava asks, here in this case, what reason is there to distinguish? Even if they do not wait and she is found to be pregnant, it is clear who the child's parents are. She's only been with this man. They converted at the same time. Are we really going to make them wait 3 months? Answer, yes. And here's the reason. The Gemara explains, here too there is a need to distinguish between seed that was sown in sanctity, i.e. a child conceived by Jewish parents, and seed that was not sown in sanctity, i.e. a child conceived by non-Jewish parents. Here what we're talking about sanctity is sanctity of the Jewish people. So Rava stated a different reason for the need to wait. It is a rabbinic decree, lest a child be born and be incorrectly identified as the son of his mother's second husband, when he is in fact the son of her first husband. This could result in what? It could result in him marrying his paternal sister, unaware of the true relationship between them, or consummating a yibum with the wife of his maternal brother, under the misconception that his maternal brother was also his paternal brother. And this would be prohibited because the prohibition to engage in relations with one's brother's wife is waived only in the case where there is a mitzvah of yibum, which applies only to paternal brothers, right? So it could happen in the next generation that if there was a lack of clarity over who this boy's father, if it's a male child, and who his father is, right? Because there could be later brothers born from the second husband. And if one of them ends up dying, then this boy, who we're not sure who his dad is, it really matters because certainly his other brothers are his maternal half-brothers, but they might not be his paternal brother. And yibum is something you only perform for a paternal brother. It doesn't have to be a full brother, same mother and father, but yibum applies to brothers who have the same father. Or in the event that his mother's second husband died and he was assumed to be his only offspring, he would cause his mother to go out and be permitted to the general public because, under the misconception that he was the offspring of the deceased, he assumed that there was no mitzvah of levirate marriage. Or in the event that his maternal brother died childless and the brother's widow became subject to levirate marriage, under the misconception he was the paternal brother of the deceased, he might perform chalitza and then permit his supposed Yevama to marry a man from the general public, when in fact yibum did not apply to him and therefore chalitza would not apply either. For all these reasons, you need to know who the baby's father is, and that's why they're making women wait 3 months between one marriage and another. Rav Hanania raised an objection from a baraisa. In all of those cases where the sages prohibit a woman from marrying or consummating yibum, I identify that the prohibition is due to an ordinance instituted to prevent a violation of forbidden relations. And here, with regard to the prohibition against marrying within 3 months, it is due to an ordinance for the benefit of the offspring. Rav Hanani explains the challenge. And if it is so, that Rava's reasoning of the prohibition against marrying within 3 months is correct, then all of the cases of forbidden marriages are due to an ordinance to prevent violation of forbidden relations. However, the Baraisa indicates otherwise. The Gemara defends Rava's opinion and explains that the Baraisa can be interpreted in a way that is consistent with his understanding. When the Baraisa says that this prohibition is due to an ordinance for the benefit of the offspring, right? That the child needs to know who his father is so he doesn't get into difficult situations further down the line. When he comes of marrying age, he needs to know who his maternal brothers are, who his paternal brothers are, who his cousins are, who his other relatives are. He needs to know who his father is. But it's not just for the benefit of the offspring. It means that due to the prohibition, the offspring will not encounter a prohibition of forbidden relations. If he knows who his father is, he'll know who his paternal brothers are. He'll know who his paternal sisters are. And so therefore, he won't come to accidentally commit incest because he didn't know that his father was actually the first husband and not the second. Okay, that was where I was going to complete yesterday's highlights of the previous 4 days. Now we move forward to the bottom of page 42b, where we're picking up today's reading, which is page 43. We're in chapter 4 and continuing our discussion of Mishnah number 7 here in Tractate Yevamos, right? The daf is 43, page 43. So, excuse me. The Gemara relates. Rabbi Abahu would walk while leaning upon the shoulder of Rabbi Nachum, his attendant. And along the way, Rabbi Nachum would walk and gather halachic rulings from him. Once, Rabbi Nachum asked him, when the Mishnah first records a dispute, now here we're going to go into a very interesting digression, generally about the ways that halacha, right, that normative Jewish law was derived from these discussions and debates that are recorded in the Talmud. This is a great little step back. It could have happened in this tractate. It could have happened in any tractate. But here we're talking about how, okay, so the sages, even in the Mishnah, we often have disputes recorded. And then, so the law is according to who? Sometimes the Mishnah itself will say, and the law is according to such and such. Sometimes you have an unattributed Mishnah that just records what the law is without attributing it to an author. Often those are, the unattributed Mishnahs are credited to Rabbi Meir, but sometimes we're not sure who it's credited to, but it's just an unattributed Mishnah, which usually means, and that's the law. And then when they say the unattributed position in a debate, but Rabbi Yehuda says, and then that would be a minority opinion. We just had that. Rabbi Yehuda would allow betrothal when there's no fear of pregnancy, and Rabbi Yosei also minority opinion on our Mishnah. Now, because our Mishnah seems to have an unattributed opinion and then the minority opinions of Rabbi Yehuda and Rabbi Yosei, it's triggering the sages here in the Gemara to talk about, well, wait a minute, how do we know what the law is? How do we know what the law is? These days, we would look up Rambam, right? We would go to Maimonides, or more typically, we would go to Shulchan Aruch, right? The code of Jewish law, which is basically codified by Rabbi Yosef Karo not that long ago, right? Just, Karo, I think he was about 600 years ago. And then pretty much, it was people like Maimonides and then Yosef Karo and a few other people like that, and Rashi, who sort of went through all of the debates in the Talmud and said, okay, and the law is. And that's why I often go to the note on the side here in the Koren Talmud, this published edition, and after we discuss various positions in an argument, I say, and the law is, right? And so when I go to those notes and I tell you what the law is, usually Rav Steinsaltz, who edited this, is going to Shulchan Aruch and saying, okay, and having looked at all the debates, not only in whatever particular tractate we're in, but they would have to sometimes go elsewhere to make sure that the law wasn't actually undermined in some other area of the Talmud, and say, yes, this is where the law ended up, right? So when we say, and the halacha is, that means that's where the debate ended up. Now, about that process of figuring out where the law ends up, this is what they're talking about now. So Rabbi Abahu would walk while leaning upon the shoulder of Rabbi Nachum, his attendant, and Rabbi Nachum, as he's helping Rabbi Abahu, would often gather, sort of halachic rulings from Rabbi Abahu. So once, Rabbi Nachum asked Rabbi Abahu, when the Mishnah records a dispute, and afterward it records only one side of that dispute as an unattributed opinion, what is the law? Rabbi Abahu said, the law, the halacha, is in accordance with the unattributed opinion. Rabbi Nachum then asked, well, when the Mishnah first records an unattributed opinion and afterwards records that the ruling is subject to a dispute, then what is the law? And Rabbi Abahu said to him, the halacha is not necessarily in accordance with the unattributed opinion. Right, so when we encounter a Mishnah that only has one position and it's an unattributed position, then we're pretty confident that that's the law. If it says the law, in such and such a case, the law is like this, and then there's another side to the argument, right? So an opposing viewpoint, and it doesn't say, and the law is, right? It just records one side of the law and then the opposite position, maybe in somebody's name. So says Rabbi Abahu, then you can't be sure what the law is. Then you require further study. Rabbi Nachum asked, when a ruling is recorded in the Mishnah as unattributed, but it is subject to a dispute in a baraisa, then what is the halacha? So what are the baraisas? Baraisas are contemporaneous with the Mishnahs, but somehow there was something questionable, something that was not fully authoritative. And so Rabbi Yehuda and Yosei did not see fit to include that particular ruling in the Mishnah. Rulings that made it into the Mishnah, especially if they got in there unattributed, that's the most authoritative law we have from the Mishnaic period. If it didn't get into the Mishnah, but it did get into a Baraisa, well, then there was something questionable. So very often we study Baraisas to help our understanding of what's in the Mishnah, but always remembering that the Baraisas are not as authoritative as the Mishnahs, okay? So, if we have an unattributed opinion in the Mishnah, and then there's a Baraisa that addresses the same issue and shows that there was a dispute between two sides, then what is the law? Rabbi Bahu said to him, the halacha is in accordance with the unattributed opinion in the Mishnah. Rabbi Nachum then asked, when the Mishnah records that a matter is subject to a dispute, and only one side is recorded as an unattributed opinion in a Baraisa, then what is the law? And Rabbi Abahu said to him, if Rabbi had not taught that ruling in the Mishnah, from where would Rabbi Chia, his disciple, right, Rabbi's disciple, and the redactor of the Baraisas, right, the one who collected all the teachings that didn't make it into the Mishnah is Rabbi Chia. He's the one who collected them in the Baraisa, as the collection of Baraisas. So where would Rabbi Chia, who's the student of Rebbe, have gotten his Baraisa, have gotten this dispute? From where would he have known it? Since the source of the unattributed ruling in the Baraisa is certainly the dispute recorded in the Mishnah, its lack of attribution in the Baraisa only reflects the fact that Rabbi Chia himself ruled in accordance with that opinion. But that cannot be used to indicate that what was stated in the Mishnah as a disputed ruling ended up being undisputed. No, it just meant that Rabbi Chia agreed with that side of the argument. Rabbi Nachum questioned the principle that the halacha is always in accordance with an unattributed ruling in a Mishnah, and said to Rabbi Chia, didn't we learn in a Mishnah at Kalim 13:8 that a comb made for combing beaten flax in preparation for spinning, from which its teeth were removed, and only two of the teeth of this comb remained in it, it is still suitable for combing. It is therefore considered a utensil and will become ritually impure if it comes into contact with ritual impurity. So what they're getting at here is a tool, a utensil, a vessel made out of certain kinds of material like metal. So if it comes into contact with tuma, ritual impurity, for example, a dead creeping thing, or a human body, which is the ultimate source of ritual impurity, so then that vessel will become tameh. But if the utensil or the vessel is broken, and it can no longer serve its intended purpose as a utensil or a vessel, then it is no longer subject to tuma. It cannot become ritually impure because it is no longer a vessel or utensil because it was broken. Okay, so now about this class of utensils, which are combs used in the process of making linen, right? Linen comes from flax. So this comb, if it only had a couple of teeth left, so it's so broken that it's not a utensil anymore and it cannot become tameh. However, if only one tooth remained so that the comb was no longer suitable for combing, it is no longer considered a utensil, and so it will remain tahor, ritually pure, even if it comes into contact with ritual impurity, because it's not a utensil anymore. So this comb, if it even had two teeth, okay, so it would not be a good comb, but it could be used as a comb, so it can become tameh. But if it lost all its teeth but one, you can't comb with it anymore. It's just useless. It's totally broken. Therefore, it's tahor. It cannot become tameh. And with regard to any of the teeth of that comb that were individually removed on their own, they do serve a purpose, right? The individual tooth that was broken off a comb, even though the comb is no longer functional as a comb, the teeth themselves of the comb, if they get broken off, they can be used for something. They could be used as a toothpick or as a hook Therefore, it is a utensil with a use, and it can therefore become tameh if it comes into contact with tuma. So a comb made for combing wool, from which every other one of its teeth was removed so that no two consecutive teeth remained in place, it is no longer suitable for combing and so will remain ritually pure. If 3 teeth remain. Now, I'm going to read this whole ruling, right, this whole Mishna about whether a comb can become a tameh or not, depending on its level of brokenness. Why are we learning this right now? Because it's going to become a valuable example for talking about if you have an unattributed Mishnah, is it the law? If there's a dispute and there's a minority opinion, how do we know which ended up being the law and which didn't? If it's disputed from a barais, etc. It's being used as an example, and it's going to help us then come back to our Mishnah about a woman waiting 3 months after coming out of a marriage, and the fact that there's minority opinions from Yehuda and Yosei. We'll come back to that. But right now we're learning this principle about how we know when something is the law or not. So, a comb made for combing wool, from which every other one of the teeth was removed, so that no 2 consecutive teeth remained in place, this is no longer suitable for combing, and so it will remain ritually pure. If 3 teeth remained in it in a single place, so there's 3 teeth in a row, so then it can be used for combing and it could become ritually impure. However, if one of those teeth was the external frame of the comb itself, well, then it could not function as a comb, and so it will remain ritually pure. If 2 of the teeth were removed and made into small pincers, then they could become ritually impure because it's a useful tool. Alternatively, if one of the teeth was removed and it was prepared in a manner that made it suitable for use in cleaning an oil lamp or for stretching ropes, well, then it could be considered a utensil and could become ritually impure. Now, that's interesting because the comb was made for combing flax as part of the process of making linen. But you could take 2 teeth out of that comb or the comb itself, and even though it's no longer useful for combing flax, it could be used for something else, like adjusting the wick of a Shabbos lamp, not on Shabbos. So then it's a useful tool, and therefore it would be subject to tuma, even though not for its original intended purpose. If it's a useful tool, it can become tameh. Now, Rabbi Nachum posed his question, but we maintain that the halacha is not in accordance with this Mishnah about the comb. This would seem to contradict the principle that the halacha is always in accordance with an unattributed opinion. This was an unattributed opinion. Why isn't the halacha in accordance with that Mishnah? Rabbi Chia said to Rabbi Nachum that the principle applies to all cases except this Mishnah. As with regard to this particular Mishnah, there are Rabbi Yochanan and Reish Lakish who both say this is not an authoritative Mishnah, and so it cannot be relied upon for a halachic ruling. Somehow, Rebbe made a mistake. In all the hundreds of Mishnahs that he redacted and included in the collection of Mishnahs known as the Mishnah, he made a mistake. And for some reason, this one, which is an unattributed Mishnah, is not authoritative. We could never say that. Rabbi Yochanan and Reish Lakish, who lived much closer in time to Rebbe and the authors of the Mishnah, or the authors of various Mishnayos, they could say it. We can't. They can't. The Gemara asks, what is the reason to say that this Mishnah is not authoritative? And Rabbi Huna bar Manoach said, in the name of Rav Idi, the son of Rav Ika, it is because the first clause of that Mishnah contradicts the latter clause, as it teaches a comb used for wool from which every other one of its teeth was removed is no longer considered a utensil, and so it will remain tahor, ritually pure. This implies that if 2 teeth were to remain in one place, it would become tameh. It would have the possibility of becoming ritually impure. And then the Mishnah continues and teaches, if 3 teeth remained in a single place, then it is considered a utensil, and so it could become ritually impure. And this indicates that if there are 3 teeth in a row, yes, it could become ritually impure. Yes, it is a valid utensil. But if there were only 2, no, it would not become ritually impure. So you see in one part of that Mishnah, it says, if it has 2 teeth in a row, it can become tameh. But in that same Mishnah, it says you need 3 teeth in a row for it to become tameh. So there's an internal contradiction in that Mishnah. The Gemara says, what are you talking about? What is the difficulty? We can explain away this apparent contradiction. Perhaps this ruling that if 2 teeth remain, it is considered a utensil, this is referring to the internal teeth found in the middle of the frame of the comb. While that ruling that it is not considered a utensil unless there are 3 teeth, that is referring to the outer teeth which are adjacent to the frame of the comb and makes it unsuitable for use. Rather, the difficulty with the Mishnah is not that. It's not the contradiction of 2 versus 3 teeth. It is from here, as it teaches, and any of the teeth that were individually removed on their own, since they can serve a useful purpose, they are considered utensils and they can become ritually impure. And the implication is that this is true even though the tooth was not prepared for that purpose. It wasn't intended, it wasn't fashioned to become a hook or something, used for something else, but if it's usable for something, then it can become tameh. But say that the latter clause, which says if one of the teeth was removed and it was prepared in a manner that rendered it suitable for use in cleaning an oil lamp or stretching ropes, then it would be considered a utensil and could become ritually impure. The implication is that if it was prepared for use of a certain kind, then yes, it would be subject to impurity. But if it was not prepared for that use, even though you could use it that way, it would not become subject to impurity. Abaye said, but what is the difficulty? Perhaps this ruling that further preparation is not required before it is considered a utensil is referring to a case where the teeth were removed with their base, which allows them to be used immediately for various functions. Whereas that ruling, that it is considered a utensil only once it is prepared for use, is referring to a case where the teeth were removed without their base, and therefore require further preparation before you could use it for something else. Rav Papa stated an alternative resolution. They're answering the question, why is that Mishnah considered not authoritative? That is the outcome, right? That this is the one Mishnah that is considered no good, not authoritative. It's got some kind of internal contradiction. Now the various sages are speculating on what that internal contradiction is. So Rav Papa states an alternative resolution. What is the difficulty? Perhaps this ruling that further preparation is not required is referring to a case where the teeth were narrow, whereas that ruling that it is considered a utensil only once it is prepared for use is referring to a comb where the teeth were thick. Rather, the reason that the Mishnah is not acceptable, is not considered authoritative, is not due to some difficulty in the formulation of the Mishnah, but because those who are exact in their rendition of the tradition conclude this particular Mishnah with, this is the statement of Rabbi Shimon. That's what was left out. It is not an unattributed Mishnah. Actually, it is an attributed Mishnah, which means that it might well be a minority opinion, and that is why we don't rely on it as halacha. Rabbi Yehuda bar Avin sent a message from the land of Israel with regard to the law cited in our Mishnah now, Mishnah number 7 here in Tractate Yevamos. One may betroth a woman. So that's where they left it off, right? So this is the only Mishnah that's considered unattributed. And it turns out it's not because there's some kind of internal contradiction, but rather because somewhere along the line, the attribution to Rabbi Shimon got left off. And that's where they leave that conversation. Okay, now we're back to our Mishnah, Mishnah 7 here in chapter 4. So Rabbi Yehuda bar Avin sent a message from the land of Israel, right, to Babylonia, the Jewish community in Babylonia, with regard to the halacha cited in our Mishnah. One may betroth a woman, but not marry her within 3 months of her previous marriage, and so one acts in practice. Now, the unattributed Mishnah in our Mishnah was, no, you can't do that, right? You have to wait at least 3 months, this woman coming out of a marriage, and then she can get married, and even she has to wait 3 months before she gets betrothed. Now Rabbi Yehuda bar Avin is saying one may betroth a woman, though he cannot marry her, within 3 months of her previous marriage, and that people actually do this. And so Rabbi Elazar would teach us in the name of Rabbi Hanina the Great that the 3 months are counted as follows. One counts the majority of the days of the first month and the majority of the third month and the entire middle month. So now they're saying, well, it's not actually 90 days. You just need part of the first month, the whole middle month, and part of the last month. In fact, you need the majority of the first month and the majority of the last month. So it would sound like the 3 months becomes like, 8 weeks and maybe 2 days or something like that. A Maimar permitted one to betroth a woman in the 90th day itself. Rav Ashi, now he's saying, no, it's 90 days. And now the question is, can you use the 90th day itself? Can the woman get betrothed exactly 90 days after she comes out of a previous marriage? Rav Ashi said to a Maimar, didn't Rav and Shmuel both say that she needs to wait 3 full months, excluding the day on which the husband died and excluding the day on which she's betrothed to her new husband? It is apparent that it is still prohibited to betroth a woman on the 90th day itself. A Maimar said to him, that which you heard, that the days of the husband's death and the betrothal are not included, this was stated only with regard to a nursing woman. As it was Rav and Shmuel who both said, a nursing woman needs to wait 24 months before being betrothed, excluding the day on which the baby was born and excluding the day on which she is betrothed. Okay, now we have a completely new ruling that we haven't been talking about at all. So far we've said that a woman has to wait 3 months when she's coming out of a marriage before she can enter a new marriage because there might be uncertainty as to who is the father of the baby if she happens to be pregnant and she doesn't even know she's pregnant when she's leaving the first marriage. Now they're saying if she is nursing a baby, she has to wait 24 months before she gets betrothed even. It's like, what? Now we're not talking about uncertainty of who the father is. Now, this is a mom, right? So let's say she's a single woman. She's a single mother, and she's nursing a baby. Now we're getting a completely new ruling. If the woman has a baby and she's nursing that baby, in fact, it doesn't even matter whether she's nursing it or not. The sages are sort of assuming that any mom with a baby would nurse the baby. How long is the normative time for nursing the baby let's say in Talmudic times? 2 years. And during those 2 years, she shouldn't be getting married to a new guy. This is a very restrictive rule and goes way beyond what we were talking about before. But indeed, what is the law? Here's the halacha, right, from Shulchan Aruch, and quoted by Rav Steinsaltz. Pregnant women, now where you know she's pregnant, and nursing mothers may not be betrothed and certainly not married until the period of nursing has ended. And the time established by the sages for this period is 24 months, excluding the day of the child's birth and the day of betrothal. A woman who is widowed or divorced and is not pregnant or nursing must wait 90 days, excluding the day of the husband's death or the divorce and excluding the day of the betrothal. So now we have 2 different rationales here, right? So one thing is the 3-month waiting period is because she might be pregnant and we don't know it. But if she's pregnant for sure, then she has to wait until the baby is born. Presumably, if God forbid the baby was a stillborn, it was not a viable baby, okay, then the waiting period is over. She can go and get betrothed or get married. But if it's a viable baby and she's going to be nursing that baby, 24 months she has to wait from the day of the birth. Very different rule that we're learning now for the first time. 24 months. And the Gemara asks, wasn't there an incident concerning a certain person who prepared a betrothal feast on the 90th day following the death of the woman's first husband, and Rava caused him to forfeit his feast by prohibiting the betrothal on that day. And the Gemara answers that feast was actually a marriage feast, but had it been a betrothal feast, it would have been permitted, according to this opinion. But as we saw in the law, no, she has to wait 90 days. When they say 3 months, in this case, they mean a full 90 days. And the betrothal itself can't happen on the 90th day. It can only happen on the 91st day. The Gemara summarizes the halacha is that a nursing mother needs to wait 24 months, excluding the day on which the baby was born and excluding the day on which she is betrothed. And if she was widowed but was not nursing, then she needs to wait only 3 months, excluding the day on which her previous husband died and excluding the day on which she is betrothed. And that is the law. The Mishna states, our Mishnah, now going back to our Mishnah and the 3-month waiting period, here's the minority opinion. Rabbi Yosei would allow them to become betrothed if it's clear that they're not pregnant, but that's not the law. Now the Mishnah states that Rabbi Yosei says all women may be betrothed within 3 months, except for a widow, due to the mourning period that she must observe for her deceased husband. It's not the law, it's Rabbi Yosei's position. Now we're examining Rabbi Yosei's position. Rav Chisda questioned the Mishnah's ruling and said, based on a kal v'chomer inference, a fortiori inference, it should be permitted for a woman to be betrothed during the 30-day mourning period for her husband. Right? Rabbi Yosei was talking about even if the woman is not pregnant, and we know she's not pregnant, so therefore she should be allowed to get betrothed unless we're talking about a widow. And a widow needs to wait a certain amount of time, not because of uncertainty of who the father of the baby is, but because if we know she's not pregnant, then she wouldn't have to wait. But nonetheless, she should not become betrothed during her mourning period. But now that Rav Chisda is challenging that, he says, if during another period of mourning, which the Gemara will specify momentarily, when it is prohibited even to launder clothing, and yet it is permitted to be betrothed, then during the 30-day mourning for the husband, right, when a woman becomes a widow, so she has 30 days of mourning for her husband. That's it. Not like when somebody's parent dies and they have 11 months of mourning. But when you lose your spouse, you have 30 days of mourning. We're talking about beyond the Shiva. The Shiva, there's the acute mourning, which is the first day. Then there's the extensive mourning requirements of the first week, the Shiva. And then there's lesser restrictions, but still important restrictions for the Shloshim, the first 30 days. Now, during those 30 days after the Shiva, you can wash your clothes. Why not allow betrothal? If, when we're about to talk about Tisha B'Av, when you're not even allowed to launder your clothes, but you are permitted to become betrothed. So, when it is prohibited to launder clothes, one may become betrothed. Then, during the 30-day mourning period for a husband, when it is permitted to launder clothing, isn't it logical that it should also be permitted to become betrothed? And the Gemara explains the cases which are involved in this dispute. What is the period of mourning to which Rav Chisda is referring? As we learned in a Mishna, in Tractate Tainus, which we learned together on page 26, during the week in which Tisha B'Av occurs, the 9th of Av, when we commemorate the destruction of the first and second temples and various other tragedies in Jewish history, during that whole week, it is prohibited to cut hair and to launder clothing. But on Thursday, it is permitted in deference to Shabbos, and it is taught in a baraisa. Prior to this time, the public reduced their activities, refraining from business transactions, from building and planting. And they may betroth women, but they may not marry them. You can become betrothed, but you can't have a chuppah, you can't have a wedding. And they may not make a betrothal feast. Nonetheless, they can become betrothed. The Gemara assumes that the baraisa is referring to the days immediately preceding the 9th of Av. Accordingly, during the days prior to the 9th of Av, it is prohibited to launder clothing, but it is permitted to be betrothed. And it was based on this period of time that Rav Chisda is basing his kal v'chomer. If during the days leading up to Tisha B'Av, you may not launder your clothing, but you may betroth a woman, Then during the Shloshim, when it is permitted to launder one's clothing, all the more so it should be permitted to become betrothed. If Rabbi Yosei is saying that the only reason that a widow should not become betrothed during that period is because she's in her period of mourning, well, it's not that heavy of a period of mourning. Why not let her become betrothed? Okay, she can't actually marry her new husband, but why not betrothed? To defend Rabbi Yosei's ruling in the Mishnah, the Gemara explains, when that Baraisa is taught, it is taught with regard to the period prior to the period that is prior to the 9th of Av, i.e. the days prior to the week in which the 9th of Av occurs. It is only then that it is permitted to be betrothed. But during the actual week in which the 9th of Av occurs, it is prohibited. Therefore, the basis of Rav Chisda's Kal V'Homer argument is undermined. Rava said, from the period prior to the period that is prior to the 9th of Av, a challenge to Rabbi Yosei's ruling can also be advanced based on a Kal V'Chomer inference, as follows. If in a period of mourning, when it is prohibited to conduct business transactions, it is permitted to be betrothed, then during the 30-day mourning period for a husband, when it is permitted to conduct business transactions, isn't it logical that it should also be permitted to become betrothed? The Gemara accepts the conclusion of this Kal V'Chomer inference and therefore concludes, do not say that Rabbi Yosei says all women may be betrothed within 3 months. Rather, amend his statement to say all women may be married within 3 months except for a widow. However, even Rabbi Yosei agrees that it is permitted for a widow to become betrothed during this period. Although the law is nobody can become betrothed during those 3 months. The Gemara asks, but does Rabbi Yosei, now we're on 43b, not accept that there is a decree to wait 3 months in order to distinguish between the seed of the first and second husbands? According to the Gemara's emendation of his statement, it would appear that there is no case in which Rabbi Yosei applies the decree that we should wait 3 months to be certain who the child's father is. The Gemara answers, indeed, he does not accept the decree. And if you wish, say that actually he does accept the decree and he applies it in the case of a married woman who was divorced. And with regard to the challenge to his opinion from the Kal V'Chomer inference, amend the Mishna and say, Rabbi Yosei says that all women who are only betrothed to their previous husbands and then divorced, they may be married within 3 months, since the reason to wait does not apply in this case. Right? Rabbi Yosei would agree with Rabbi Yehuda that a woman who was only betrothed to the first husband, right, meaning they never consummated, they never became actually married. So this woman is a virgin. She never slept with anybody. There's no possibility that she's pregnant. Why should she have to wait 3 months? There's not going to be any ambiguity of when she eventually gets pregnant from the second husband of who the child's father is. Answer, according to the majority of the sages, we don't allow that because of cases where there might be ambiguity. But Rabbi Yosei would allow it. Now the Gemara asks, if so, then this opinion of Rabbi Yosei is identical to the opinion of Rabbi Yehuda. What difference is there between them? And the Gemara answers, there is a practical difference between them in the case of a woman who was married to her previous husband and now seeks to be betrothed. Rabbi Yehuda holds that it is permitted to betroth a woman who was married to her previous husband without first waiting 3 months, because she's not going to sleep with the second husband until the 3 months are over. It's only betrothal that Rabbi Yehuda permits. And Rabbi Yosei holds that it is prohibited to betroth a woman who was married to her previous husband without first waiting 3 months. The Gemara asks, but does Rabbi Yosei really hold that it is prohibited to betroth a woman who was married to her previous husband without first waiting 3 months? Isn't it taught in a Baraisa? Rabbi Yosei says that all women may be betrothed without waiting, except for a widow, due to the mourning period that she must observe for her deceased husband. And how long is her mourning period? It is 30 days. And none of them may be married until they have waited 3 months. The Gemara clarifies the question. What difficulty does this Baraisa pose if we say that the Baraisa teaches? Rabbi Yosei says that all women may be betrothed without waiting, Is the Baraisa stronger than the Mishnah that was established as teaching that women who were only betrothed to their previous husbands and then divorced may be married within 3 months? Here too, the Baraisa could be established as teaching that all women who were only betrothed to their previous husbands and then divorced may be married within 3 months because they never slept with the previous husband to whom they were only betrothed. Why are they getting divorced if they never slept with him? Because betrothal is like marriage without consummation, and to get out of a Jewish betrothal, you need a bill of divorce. But since she never slept with her betrothee, she couldn't be pregnant, and that's why Rabbi Yosei and Rabbi Yehuda would allow her to at least get betrothed, if not married, to a new husband, but the sages disagree. Rather, the difficulty arises from the latter clause of our Mishnah that teaches, with respect to Rabbi Yosei, and none of them may marry until they have waited 3 months. Marry as opposed to betroth. This implies that Rabbi Yosei holds that it is specifically marrying that is not permitted, but betrothing is okay. And this challenges the Gemara's original claim that Rabbi Yosei disagrees with Rabbi Yehuda on this point. Rava said, resolve this difficulty and amend Rabbi Yossi's statement to say like this. Rabbi Yosei says that all women who are only betrothed to their previous husbands and then divorced may marry within 3 months, except for a widow, due to the mourning period she must observe for the deceased husband. And how long is her mourning period? 30 days. And women who are married to their previous husbands may not be even betrothed until they have waited 3 months. The Gemara asks, but does a woman who became a widow from betrothal have to observe a mourning period for her husband? If she was only betrothed, does she have a shloshim? Does she have a 30-day mourning period? Like she would if she was fully married to the guy? Didn't Rabbi Chia bar Ami teach in a Baraisa? If one's wife, to whom he was only betrothed, not married, if she died, he does not observe a period of acute mourning, that's the first day. And if he is a priest, he is not permitted to become ritually impure for her, like he would for his full wife. And similarly, if he dies, she does not observe a period of acute mourning for him, and she does not become ritually impure for him. If she dies, he does not inherit from her. If he dies, she collects payment of her marriage contract. The Baraisa demonstrates that a widow, is required to mourn her husband only if she is married to him and not merely betrothed. If so, clearly Rabbi Yosei's ruling in the Mishnah is referring to married women, not merely betrothed. Accordingly, all of the Gemara's emendations of Rabbi Yosei's statement in order to defend his statement from Rav Chisda's Kal V'chomer inference are refuted. Rather, it must be, and I'm almost done, so if you got questions or comments, get them in. It must be that the question of whether it is permitted to betroth a woman during the period prior to the week of the 9th of Av is subject to a dispute between the Tanaim, the rabbis of the Mishnah, as it is taught in a Baraisa, from the new moon of Av, meaning Rosh Chodesh Av, from the 1st of Av, until the fast on the 9th of Av. The public reduces its activities, refraining from business transactions, from building and planting, and from betrothing and marrying. During the week in which the 9th of Av occurs, it is prohibited to cut hair and to launder clothes, and it is prohibited to be betrothed. This is the 9 days. And some say it is prohibited for the entire month. The Gemara is challenged to Rabbi Yossi's opinion that it is prohibited for a widow to be betrothed during her mourning period was based on a Kal V'chomer inference that assumes that it is permitted to be betrothed during the mourning period preceding the week of the 9th of Av. However, since this ruling itself is subject to a dispute, Rabbi Yosei could reject the Kal V'chomer inference by stating that he holds in accordance with the opinion that it is in fact prohibited to become betrothed during that period. Now, Rav Ashi strongly objects to this. From where is it known that when the Baraisa prohibits one to be betrothed, it is referring to actual betrothing? Perhaps it is only to make a betrothal feast that is prohibited, but merely to become betrothed is okay, it is permitted. The Gemara questions Rav Ashi's objection, If so, then with regard to the prohibition against marrying as well, one could make the same claim. With regard to the prohibition to marry, too, it is only to make a marriage feast that is prohibited, but merely to marry might be permitted. The Gemara rejects this. How can these cases be compared? Granted, from a marriage, even without a feast, there is joy. But from a betrothal without a feast, is there any joy? It is merely a legal ceremony. Rather, Rav Ashi stated a different resolution to Rav Yossi's opinion. New mourning, i.e. the mourning of a relative who has just passed away, is different from old mourning, i.e. the mourning over historic events such as the destruction of the temple. Why would we learn rules about whether one can betroth or not during the 30 days after the death of a husband from whether one can get betrothed or not during the week before the 9th of Av? They're not the same. And the mourning of the public is different from the mourning of a private person. And it is appropriate to be more stringent in the case of the individual. As such, it is not possible to form a kal v'chomer inference from the laws of mourning for the destruction of the temple on the 9th of Av to those of a wife mourning for her husband. And that concludes the Gemara and the discussion of Mishnah number 7. With God's help, tomorrow night at 6 p.m. Pacific, our regular time, we will begin Mishnah number 8 here in chapter 4. Okay, we covered a lot of ground, and yesterday I wasn't able to answer questions because of this frozen screens. So let's see what questions Nina has queued up for me today. Hold on a second. Google signed me out of our document, but I'm getting back in. Okay. So, first, a few questions from yesterday when we did the highlights of 4 pages. Susan Marcus Warren said Yavam is brother-in-law. The Yavam is the brother-in-law in the case. He only becomes a Yavam because his brother died, right? So Yevamos is all about when a man is married, he doesn't have any children, he dies, and he leaves a widow and at least one brother. So then the surviving brother is called the Yavam, and the widow is called the Yevama. They're only called that because the law of Yibum applies to them, that the Torah says he shall step in and marry his brother's widow because his brother never had children, and thus build up the house of his brother. And they have the choice not to perform Yibum, not to enter that marriage, not to have marital relations, and perform the Chalitza ceremony instead. Until they do one or the other, they have a levered bond together, and she is not free to get on with her life and go marry some other guy if she wants until she performs chalitza with her yavam. But if the brother who died had children, then his surviving brother and his widow are not called Yavam and Yevama, even though they're the same people, because Yibum does not apply. He had children, so there is no obligation for his brother to step in and marry that widow. In fact, he's prohibited to do so because you cannot ever sleep with or marry your brother's wife. Even after your brother dies, she will always be prohibited to you unless Yibum applies. So it's when Yibum applies that the man is called Yavam and the woman is called Yavam. Rebecca, what if the woman was older and not able to have children? I'm sorry this was covered. I did miss some classes recently. So you're saying if the Yevama is unable to bear children, if it's just because she's older, no, right? Like if there's any possibility that she could have children, then they're going to need Yibum or Chalitza. But if she's known for a fact to be sterile, right? That she cannot have a baby, no way, no how, then she's exempt from Yibum, right? Because the purpose of Yibum is to build up the brother's house. If there's no way she can have a child, or no way she can be married to him because of some other forbidden relation, then Yibum does not apply. They are exempt. And not only does Yibum not apply, but Chalitza does not apply either, the alternative to Yibum. Tom, if the non-eldest brother performs chalitza, does that end the obligation of all the other brothers? Yes, right? So exactly. So that was on mission number 6, or I think number 6 or 5, that the idea that it is preferable that the oldest surviving brother perform either yibum or chalitza, But the Gemara specified that if one of the younger brothers steps in and does either Yibum or Chalitza, all the other brothers are then excused. And the Chalitza is valid or the Yibum is valid. Preferable that the oldest does it, but not required. Tom, we may have covered this, but what happens to the woman after Chalitza? I realize she can marry as she chooses, but in between, does she return to her father's house? Or if her father is dead, her brother? What if all the male relatives are dead? It's a very good question, Tom, because what you're really talking about here, especially in that ancient world, right? Single women, very precarious, right? Like a woman needed to have a home where she was under somebody's protection. And if she loses her husband, correct, she would return to her father's house, and her father inherits from her if she should die. If her father is gone, and hopefully she has a brother, then she would go to that brother's house. When we look in the book of Ruth, right, and Naomi returns to Israel with her daughter-in-law, right, her son died, and she returns with Ruth, who's her daughter-in-law from Moab, right, so Naomi doesn't really, she doesn't have her own father, her own husband is gone. Luckily, they get some protection from Boaz, who is a kinsman. He's like a cousin, he's some kind of relative, but it's not that they go live in his house. So I guess Naomi had some kind of resources. They were living somewhere, although it's unclear where exactly they were living. Perhaps there was some kind of a house that belonged to Naomi's husband before they went to Moab. I'm not sure. But it's a really good question. And then something we also saw is if there's a Yavam who refuses to perform either Chalitza or Yibum, he's just kind of, twiddling his thumbs and making her wait. So at a certain point, he becomes materially responsible for her and has to feed her, give her money for rent and food, etc., so that she's not, homeless and starving, God forbid. Okay, those were yesterday's questions, and I guess we just have one question today from Sharon. I had a question last night. If there are two wives and the one who is the Yevama enters into Chalitza or Yibum, and then it is discovered that the co-wife is pregnant, what is the status of those ceremonies or of the child? It's a really good question, right? Because as we've seen, they exempt their co-wives, right? So if this woman who's now going to perform Chalitza with one of the brothers, let's say, so that releases her, and then her co-wife is also released. The co-wife doesn't have to perform Yibum or Chalitza. As long as one of the wives gets Yibum or Chalitza, the other wife is exempt and can go on with her life. But what if among the two wives, they said, okay, you do the Chalitza and with one of these guys, and then one of the brothers, and then, I'll just go off and do my thing. Now, the one who's just going to go off and do her own thing and not do neither Yibum or Chalitza, they discover she's pregnant. What if the other one perform Chalitza in the meantime? That's going to be less of a problem than if the other one performed Yibum. Because you're exactly right, Sharon. If this one goes and performs Yibum and then learns, but her co-wife is actually pregnant, right, from the brother that died. Now, if that baby is born and it dies, within 30 days, it was a non-viable baby, okay, then the Yibum works, everything is okay. But if that co-wife turns out to be pregnant and then gives birth to a viable child, then Yibum never applied. And the one who did perform Yibum, that was a serious transgression. And God forbid she became pregnant with that Yibum, that child would be a mamzer. That's why everybody needs to wait 3 months to avoid that terrible circumstance, right? See, if everybody waits 3 months, then you won't have this problem that the one performing Yibum could get undermined by that the other one turns out to be pregnant, right? Because if they waited 3 months, they would know whether she's pregnant or not. And if she is pregnant, everything would stop. Nobody would perform Yibum or Chalitza until they, see if that child is viable or not. That's my understanding of it. Okay, we're caught up. We got through a whole daf today. We covered page 43. And with God's help, tomorrow we'll pick up Mishna number 8 and page